My Lords, my Lady, before the adjournment, I had taken you to a series of cases, Cronin Energy Financing Team and Gittins, all of which make the point that where an application is made post-execution of the warrant for disclosure of the information on which the warrant was based, disclosure is to be given subject to the application of public interest immunity. And I've taken you to the passages in those cases which show that the common law right of disclosure is to be balanced against the public interest in the effective investigation and prosecution of crime. I was going to take you to one more case, which is the case of Bangs, which gives its name to the procedure that is now used in magistrates' courts, the Bangs procedure. And that's the judgment of the Divisional Court, which you'll find in Authorities Bundle 5, tab 51, and the relevant part is in the judgment of Lord Justice Beatson at paragraph 35 on MS page 2010. What Lord Justice Beatson is doing there is he's applying a passage from Bank Mellat about the need for ensuring, when there has been a closed material procedure, that as much as possible about what happened at that procedure is disclosed into open. So just near the top of the page on 2010, he also stated, that's Lord Neuberger in Bank Mellat, that where closed material has been relied on, the judge should, in the open judgment, say as much as properly can be said about that closed material. Lord Neuberger stated at 69, any party who's been excluded from the closed hearing should know as much as possible about the court's reasoning and the evidence and arguments it received. And then this, I accept that in some cases, in the light of the nature and basis of the claim to PII, this may not be very much. I also accept that account should be taken of what is practical in a busy magistrate's court. So that's what Lord Justice Beatson said. And if one looks over the page, he makes the point that at 42 and 43 on 2011 to 2, he makes the point that it's important to give a gist. At 43, one can see it's important that a gist should be prepared. Because the full document is probably the subject of immunity from disclosure, must not mislead and should accurately reflect that part of the material in the document which it is possible to disclose. In the present case, the district judge quite properly examined the revised gist to this end, as we know District Judge Mellenby and His Honour Judge Bright did here, and concluded that it did not accurately reflect the information. Of course, that wasn't the conclusion drawn here. If, however, disclosing what the evidence was, how reliable it was, or what information confirmed it, would pose a real risk of substantial or serious harm to an important public interest, see Wiley, and non-disclosure is necessary for the proper functioning of that public interest, it cannot be disclosed in a gist. So that's how the two interests have been balanced in the context of the common law jurisdiction to order disclosure of the material in the information which supported the warrant. And we say that these cases are all Cronin Energy Financing Team, Gittins, Bangs. They all operate on the presumption that it is perfectly, that a common law court is perfectly able to perform that balance, and that there is no universal rule that disclosure must always be given, whatever the damage to the public interest that would entail. Now, if the appellant is correct that there are limits on what the magistrates can consider at the initial stage, and in particular, the magistrates cannot consider any material that can't be disclosed later to the subject of the warrant, it must follow that all of these statements of principle are wrong. And we say there is no reason to regard them as wrong. To do so would be to privilege one public interest, the public interest in open justice, over another equally important public interest in the effective investigation and prosecution of crime.
How do they fit with the usual understanding of PII, which is that the material is not relied on.
Well, they fit in this way that what they are dealing with is an application made not at the initial application for warrant stage, but at a subsequent stage. So they are dealing with an application made post-execution for disclosure. That's actually all they're dealing with at that stage. And so what they have done is they have simply applied the principles that you see in the PII case law to the question, how much am I entitled to see of the material before the warrant, before the magistrate justifying the grant of the warrant. Now, the next case is the Rossminster line of case law deals with what happens in the High Court when the High Court cannot look at the material, all the material, or indeed sometimes any of the material that was before the magistrate when granting the warrant. And we say those cases are very instructive. I'm going to come to those next under my second head, which is the procedure in the High Court on application for judicial review of a Section 8 warrant. But before I do that, can I perhaps just say what I submit you get from these cases? Mr. Summers made it sound as if the Rossminster, T.C. Coombs, Williams line of case law were in some way closed material procedure cases. They are not. They are cases that deal with the very different question of what happens when the High Court cannot look at the material which was properly before the magistrate in issuing a warrant. And his submission, of course, was that Al-Rawi shows that line of case law to be wrong. We say it shows nothing of the sort. It tells you that you can't have a closed material procedure without statutory authority. It does not tell you anything about the correctness, which has been assumed, correctly assumed, of the Rossminster, T.C. Coombs and Williams line of case law. So can I ask your Lordships and your Ladyship to go to Rossminster, which, of course, was a case decided in 1980, just before the enactment of the Police and Criminal Evidence Act. So it's relevant to understand what presuppositions would have been held at the time about how a warrant procedure works and about how the High Court should deal with a JR of a search warrant. Now, it's in Authorities Bundle 1, Tab 7, MS 619. And the Rossminster case was dealing with searches pursuant to a warrant issued in that case by a circuit judge, but it doesn't matter, under Section 20, capital C of the Taxes Management Act 1970. Now, the main issue, and the issue on which the House of Lords was divided, was whether a warrant under that provision had to particularise the offence of which the subject was suspected, or whether it was enough to say simply that the subject was suspected of tax fraud, simpliciter. The Court of Appeal thought it was necessary to specify the precise offence, so it held that the warrants were bad. The House of Lords disagreed by majority, and that dispute turned on a construction of the Taxes Management Act, so obviously doesn't concern us here. What does concern us is the proper approach of the High Court and other appellate courts to a warrant granted on the basis of material which can't be shown to the High Court. Now, one can see that in the judgments both of the Court of Appeal and of the House of Lords, but can we start with the Court of Appeal? At 6 MS 638, you have the judgment of Lord Denning in the Court of Appeal. And if you look at letter B, just above letter B, he says, it's under the statute that Mr. Quinlan went to the appropriate judicial authority, in this case a circuit judge, the common sergeant, I would like to know the information which was given to the judge, the nature of the evidence which was put before him to found the suspicion, and the offence of which the accused was suspected. I would also like to know why these private homes were believed to hold incriminating material. But we have not been given any information as to what the Common Sergeant was told. The Revenue take the view that it would not be appropriate for us at this stage to know what were the grounds of their suspicion. If the court were told them, it would follow equally that Mr. Bateson and his clients would be told them also. So we must remain in ignorance of the information which was laid before the Common Sergeant. But I must say, and I think it right to say, that we should assume that there was laid before the Common Sergeant material which did justify the view that there was reasonable ground for suspecting that the applicants had been guilty of an offence involving some fraud on the revenue, and also that incriminating documents would be found in those offices and homes. And exactly the same analysis can be seen, and this part of the analysis, by the way, wasn't controversial at all. It was assumed to be correct by all the judges in the Court of Appeal and in the House of Lords. So if one goes forward to Lord Justice Brown, which you have at 644, MS 644, letter G, in the applicant's original statement under Order 53, they asked for certiorari to quash the warrants on the ground there was no sufficient evidence to satisfy this judge. But in this court, Mr. Bateson could not and did not persist in this part of the application because no information or evidence is available to us about what material was before the circuit judge. And the correct way legally to understand that is then set out by Lord Justice Gough, as he then was, on 648, letter G. We do not know what was the evidence on oath on which the circuit judge authorised the issue of the warrants in this case, and therefore, in my judgment, we cannot consider whether it was sufficient, and we must, I think, proceed upon the assumption that it was, and that he acted regularly. So that's the principle applied by the Court of Appeal. Now, Lord Wilberforce deals with it in a bit more detail in the House of Lords. If we go forward to 665 and then letter D, just above letter D, if the judge does his duty, and we must assume that the learned Common Sergeant did in the present case, he must carefully consider for himself the grounds put forward by the revenue officer and judicially satisfy himself in relation to each of the premises concerned that these amount to reasonable grounds for suspecting, etc. It would be quite wrong to suppose that he acts simply as a rubber stamp on the revenue's application. We've already made the point, of course, that the ability to look at closed or sensitive material makes it less likely, not more likely, but less likely that the judge will act as a rubber stamp, and more likely that he or she will have the material which will enable him or her closely to scrutinise the reasons given for suspicion. So that was Lord Wilberforce. And then if one looks forward to Lord Diplock at 676, this is perhaps the fullest treatment of it, and it explains why it is appropriate to make the assumption that all the judges talk about in this case. And one sees it just below letter F on 680, where Parliament has designated a public officer as decision maker for a particular class of decisions. The High Court, acting as a reviewing court under Order 53, is not a court of appeal. It must proceed on the presumption omnia praesumuntur rite esse acta, until that presumption can be displaced by the applicant for review, upon whom the onus lies of doing so. Since no reasons have been given by the decision maker, and no unfavourable inference can be drawn for this fact because there is obvious justification for his failure to do so, the presumption that he acted intra vires can only be displaced by evidence of facts which cannot be reconciled with there having been reasonable cause for his belief that the documents might be required as evidence, alternatively, which cannot be reconciled with his having held such
You
belief.
said 676, it's 680 already.
I'm sorry, yes, 680. There is another passage in Lord Diplock at 676D, where he refers to the presumption is that he, the magistrate, acted lawfully and properly.
Yes.
And it's only fair to him to say that, in my view, there is nothing in the evidence before your lordships to suggest the contrary. So, in fact, what Lord Diplock is doing is he's applying the presumption of regularity at two stages. First, he's applying it to the exercise of the power to grant the warrant. That's the exercise by, in that case, the circuit judge of the power to grant the warrant. And then he's applying it later at 680, and he explains it in more detail at 680, to the decision by the revenue as to which documents to seize. So both of these attract, in Lord Diplock's view, a presumption of regularity. Now, this presumption of regularity was, the Rossminster case is not a sort of aberrant case. The same passage was applied later in the T.C. Coombs case, which you have in the same bundle at tab 11. And the T.C. Coombs case, what was under challenge there was not a warrant granted by a judicial officer, but a notice requiring the delivery up of documents given by a tax inspector with the consent of a commissioner. But the same principles in relation to regularity apply. Now, in this case, the judgment in the Court of Appeal, one of the judgments in the Court of Appeal was given by Lord Justice Bingham, and his reasoning is reflected in Lord Lowry's speech in the House of Lords, which you have at 728 and over the page. He sets out there what Lord Justice Bingham said. He says this, if one looks at the quote just at letter H, "If, as I think, the case is one in which the inspector could not be expected to give reasons for his opinion, either at the time he gave the notice or when the reasonableness of his opinion was challenged, there is only one question to be asked. It is, do the applicants show that the inspector did not hold the opinion he claims to have held, or if he did hold it, that that opinion was not reasonable? In a case covered by Lord Diplock's ruling," and that's the passage we've just seen at 680 from the Rossminster case, "the applicant must adduce evidence of facts which cannot be reconciled with there having been reasonable cause for the inspector's belief that the documents contained or might contain information relevant to the taxpayer's liability. The onus is on the applicant for judicial review. His task is, I think, the same, whether he is seeking judicial review or challenging on the same grounds the validity of the notice by way of defence to penalty proceedings." So that's what, if, I think before the adjournment, my Lord Hughes asked me the question, well, does my submission denude a judicial review of any efficacy? The answer is given by these cases, no, it doesn't denude, it doesn't mean that you can't bring judicial review proceedings. It just means that on the precise question whether the materials before the magistrate were sufficient to enable the magistrate to be satisfied of the statutory criteria, on that precise question, one has to apply the presumption of regularity. And my Lord put to me, well, does that really mean that actually the judicial review is useless? Well, one very good example that shows that the answer to that question is no is the first judicial review in this case. Because in this case, what happened in this case, you'll know from the background, is that the magistrate granted the warrant, and that was challenged in judicial review proceedings. I can give you, I'm not going to take you to them, but I'll just give you, for the moment, the references to where you can find those proceedings. The grounds for judicial review are in Appendix 2 at MS 239, and the consent order made in the judicial review proceedings is at MS 177. So the appellant didn't know what the grounds were that were in front of the magistrate, but still challenged in judicial review the search warrant, and did so successfully. And
well,
that's
there may be all
because,
manner of reasons for that.
indeed,
Yes.
indeed. And so...
But, I mean, looking at it theoretically,
Yes.
in a substantial majority of cases, surely, judicial review will not be efficacious.
That's absolutely right. And I don't shrink from that, and neither does the House of Lords in the T.C. Coombs case or in the Rossminster case.
Well, were they confronted with that reality, which we must face today?
Well, I accept that, and that's why I'm trying to show your lordships and your ladyship that this conundrum is not a new one. It's one that's been faced by the courts. And even in the Rossminster case, it was said, well, if this is right, then you're denuding our right of challenge of any real efficacy. And the answer was, well, on this particular point, the particular point being whether the material before the magistrate justified reasonable suspicion of the matters set out in Section 8, on that particular point,
When you say on that particular point, that will be the critical point.
Well, it may be. It wasn't in the first. It wasn't in the first judicial review in this case, because there were things on the face of the warrant that enabled the claimant to say that the warrant had been improperly granted, and that was conceded in the proceedings. So if one looks down at 729 at what Lord Lowry was saying here, again he quotes Lord Justice Bingham. The revenue are, in my view, entitled to rely on the rule that where acts are of an official nature or require the concurrence of official persons, a presumption arises in favour of their due execution, and he uses a rather longer Latin maxim than we saw previously, but it's the presumption of regularity again. And then looking further down, one can see at letter C, the case for the validity of the second notice is supported by the presumption of regularity, which is strong in relation to the function of the Commissioner under Section 20, subsection 7. He is an independent person entrusted by Parliament with the duty of supervising the exercise of the intrusive power. And we say, of course, the same is true of the magistrate under Section 8. The Commissioner must be taken to be satisfied that the inspector was justified, and hence the inspector held and reasonably held the opinion required by Section 20, subsection 3. Presumption that that opinion was reasonable and the Commissioner was right to be satisfied can be displaced only by evidence showing that at the time he couldn't reasonably have held that opinion.
Well, what sort of evidence, what species of evidence can you summon up when you don't know what the basis for his decision is?
I agree. I'm not suggesting that it will often be possible to do this, and that's actually something that's confronted directly by Lord Hoffman in the Williams case, as we're going to see in just a moment. He accepts it. He says, to all intents and purposes, on that particular point, the warrant is not going to be challengeable. Now, of course, your Lordship puts to me, well, this is a very unsatisfactory position, and of course, our answer to it is to move to the second half of issue 2 and say that's precisely why we say the High Court should be enabled to look at closed material. So what we're dealing with on this first half of issue 1 is what happens if the High Court can't look at closed material? The answer is that very clear from the authorities, you apply the presumption of regularity, and in most cases, not all, but in most cases, the challenge succeeds. But your Lordship puts to me, well, this is all very unfair, and we actually put forward the ability of the High Court
that's
to...
the subtext, I think.
That's the, well, I'm afraid it was a bit... I hope not an accurate paraphrase of my Lord's point. But fundamentally, the answer we give is that we say the ability of the High Court to look at closed material would enhance the fairness of the procedure, because it would enable the High Court judge to be satisfied as to whether the material properly before the magistrate was in fact enough to justify the reasonable belief.
Like my lord, I was wondering whether they really confronted the question in Coombs and Rossminster. Is part of the answer perhaps to be found on page 716? Because it rather looks as if Mr. Goldberg advanced much the same argument. 716 E to G.
716 E to G. Yeah, I mean, it's Your Lordship put to me, well, were they confronting it? And
Yes.
the answer is yes, they absolutely were.
They might.
That answer comes out even more strongly from Williams, which you've already seen, but I'm going to take you back to in just a moment, if I may. I do invite you, I'm not going to read it now, but I do invite you with respect to read the whole of Lord Lowry's speech down to the end of 731 letter H, because what he does there is he explains how the presumption of regularity played out in that case. And that does give you an indication of what was intended. Now, the next case is Williams. And that's in tab 13, MS 750. And that case did concern a warrant, so it is absolutely on point. And my learned friend tries to get something out of Williams by saying that there's a reference by Lord Hoffman to the frustration of the courts at not being able to go behind the warrant. If one just looks at the context for that, it starts at 759 in the speech of Lord Hoffman. And letter G, the next question is whether the Justice had before him information upon which he could be satisfied that Mr. McNeish had reasonable cause to suspect. Here one comes to the chief difficulty in the case, which is that their lordships, like the courts in Jamaica, have no information about what passed between Mr. McNeish and the Justice. This is entirely understandable because at the stage when the constitutional motion was launched, the criminal prosecution was still pending. It would have been contrary to the public interest for any information about the grounds for suspicion to be disclosed at that time to the respondents. The position may have been different if the civil proceedings had been commenced after the criminal prosecution was concluded. See Rossminster. But in proceedings commenced as these were during the course of the investigation, the courts are handicapped in their ability to protect the high constitutional right conferred on the citizen by section 19.1, because as Lord Diplock said in the Rossminster case, they have to try to reconcile two competing and conflicting public interests. That offences involving tax fraud should be detected and punished, and that the right of the individual to the protection of the law from unjustified interference with his private property should be upheld. But these limitations on the exercise of judicial control over the decision of the Justice to issue the warrant make it all the more important that he should make that decision with the greatest care. He has the responsibility of fulfilling the requirements of the statute, the effect of which is that for practical purposes the issue of the warrant is often likely to be incapable of effective review. And that really answers my Lord Kerr's question, or it confronts my Lord Kerr's
yes, but he does,
point.
He does admit that when the criminal prosecution is completed, a different position might be taken.
Well, it might be. It might be. Of course, these proceedings were all brought at the interlocutory stage.
What's the current position about the prosecution?
It's frozen pending the investigation is frozen pending resolution of these proceedings. So this is a real interlocutory case. Of course, it may be the case that the public interest immunity balance falls to be drawn differently depending at which stage of the case you're at, but it may not.
Immunity balance, it's not really a public interest immunity application, is it? I mean,
Well,
you're saying that the material, first of all, can be looked at by the magistrate.
yes.
And you're at the Crown Court and judicial review stage, the assumption must be made that the magistrate did have sufficient material on which to take a proper decision. So it's not a case of looking at the material to be protected by public interest and then discarding it at all stages.
Well, my Lord,
that's operating.
We respectfully submit that it can be looked at in that way for this reason. At the first stage, when you're in front of the magistrates, There's no lists at all. There is simply an ex parte application before the magistrate. And the question of public interest immunity doesn't arise at that stage at all. When it does arise, it arises either in the context of an application to the magistrates for disclosure, or it arises in the context of judicial review proceedings. When it does arise, then it really is a true public interest immunity case, because you're simply looking at what of the material that would otherwise fall to be disclosed attracts public interest immunity and is therefore inadmissible. And then you're asking the question, well, once it's inadmissible, what's the consequence of that? The consequence of it being inadmissible is that the applicant for judicial review doesn't have the material on which to impugn the warrant. And that's the reality that's being confronted in the Rossminster, T.C. Coombs and Williams cases. Once you rule out as inadmissible the material that was before the magistrate, and of course you know that the magistrate thought there was a good reason for ruling that material out, because the magistrate considered, or the district judge considered, the issue of PII. Once you know that, then what do? You know that the magistrate looked at the material. We've got to assume for these purposes that the magistrate was entitled to look at that material. That's issue one, because it's an ex parte application.
Well, it doesn't follow from the fact that it's an ex parte application that he's entitled to look at something which is never going to be disclosed to anybody, does it?
It doesn't follow inexorably, but I've already made my submissions on issue one. Yeah. So I certainly accept what your lordship says, that it doesn't follow inexorably. But if you add the fact that it's an ex parte to the fact that it's an ex parte application, all the other points I made under issue one, and the pragmatic points and what is one going to do with the bloody shirt and so forth, and you add all of that to the fact, and you then conclude under issue one, yes, the magistrate can look at material, whether or not it may later be disclosed, then at the later stage, it really is a true public interest exercise. You really are asking, is this material admissible or not? And if the answer is not, then what do? You have an apparently valid warrant issued on the basis of material which the magistrate was, one has to assume, entitled to take into account. One has to presume, see Rossminster, T.C. Coombs, Williams, that that warrant was validly issued, that it was regular, because the presumption of regularity applies to it. And if the High Court cannot look at the material that was before the magistrate, then the conclusion is that in most cases, not all, but most, the claimant will lose, because the claimant will simply not have the material with which to displace the presumption that the warrant is valid. Now, that is, as I've said,
a classic PII situation, because in the circumstances that you've just outlined, the authorities are insulated from attack by the applicant for disclosure, but the presumption kicks in to, as I say, make sure that the respondent cannot be held to account.
Well,
whereas in a classic PII situation, both parties go in with the same material without any assumptions or presumptions.
Well, with respect, my lord, it is a classic PII case because both parties go into the High Court with the same material. Once the material, that was Rossminster, both parties go into the High Court and neither of them can look, or
no, quite.
The judge can't look.
But in the Rossminster situation, the respondent is protected by the presumption. That
yes, I agree, my lord. The respondent is protected by the presumption, and that's why we say it would be an additional safeguard for claimants if the High Court could look behind the warrant at the closed material. And so the second part of our submissions on issue 2, which, as you know, are based on an analogy with Bank Mellat, which my learned friend doesn't like, but the second part of our submissions are indeed to say that the High Court can and should be able to look at that material. But before I look at that, can I just try and answer my learned friend's response to the Rossminster line of cases? Because he says his response to these cases is to say, Well, that's all very well, but Al-Rawi shows that they're wrong. And we say, with respect, there is nothing in Al-Rawi that casts even the slightest shadow of doubt on Rossminster, T.C. Coombs, Williams. Al-Rawi is dealing with a completely different point, which is whether you can have, without statutory authority, closed material in the High Court. And can I try and make that good by just looking at a couple of passages in Al-Rawi? It's in Authorities Bundle 3, tab 36, MS 1527. Now, just before I go to the passages, it's important to understand that the government's argument in Al-Rawi was that if courts can't consider closed material in national security cases, it may well be necessary to strike out claims as effectively untriable on the Khan-Duff basis. That was the government's argument. Now, as I'm going to try and show you, there was no dissent from the proposition that unless it could consider closed evidence, challenges to decisions made on the basis of sensitive material may indeed have to be struck out. The debate was about whether that possibility justified a departure from the principle of inter partes disclosure in ordinary civil litigation, not about the premise for the argument. So the premise was accepted, as I hope to show you. So if one looks at Lord Dyson at paragraph 15, he refers to a striking example, the Khan-Duff case. At 16, he says, well, it's the only case where that's happened. And if one goes forward then in Lord Dyson's speech to paragraph 50, he says, it's true that if a closed material procedure were introduced, it might not be necessary to strike out a claim such as Khan-Duff. Looked at in isolation, that would be a good thing. But the problem cannot be looked at narrowly, and in any event, it seems like cases such as Khan-Duff are a rarity.
Sorry, which paragraph was that?
I'm sorry, paragraph 50.
1578.
1578, paragraph 50. Now, going forward in the judgment, if you look at what Lord Brown said at 1587, paragraph 87, he took the view that this was one of those cases where the common law should indeed say never. Lord Dyson had said never say never, and Lord Brown said this is a case where you really should say never. But look at the consequence of that just above at 86, bottom of 86, letter E. Either cases of this kind, necessarily involving highly sensitive security issues, should go for determination by some body akin to the Investigatory Powers Tribunal, which doesn't pretend to be deciding such claims on a remotely conventional basis, or they must simply be regarded as untriable and struck out on that basis. They cannot, as Lord Justice Laws put it, in truth be justly tried at all. And then if one looks at Lord Mance's speech, with which Lady Hale agreed, at 108, page 1591, the Crown's alternative submission that a closed material procedure might be recognised after or as supplementary to a conventional PII exercise merits close scrutiny. Now, of course, Lord Mance and Lady Hale were in the minority in this respect, but it's the next part that's important. As I understand it, no member of the Supreme Court doubts the approach in Khan-Duff and Rock as a possibility. So, properly understood, this court in Al-Rawi was acknowledging, not denying, that the non-availability of a closed procedure might well make claims untriable, with the effect that a claimant's challenge to an apparently valid public act would fail. The ratio of al-Rawi was that despite this unattractive consequence, statutory authority was still required for a closed material procedure. So properly understood, al-Rawi goes no way at all to suggesting that the Rossminster line of cases, and in particular the way in which the presumption of regularity works in those cases, is wrong. Now, we say that can also be seen from the decision of Mr. Justice Ouseley in AHK. And can I just show you that briefly? It's in the same bundle, Authorities Bundle 3, tab 37, MS 1617. That's a decision that's taken in the light of al-Rawi, and it concerned an application for judicial review of a nationality decision made on the basis of sensitive material. The question there was what should happen when the Secretary of State can and must have regard to sensitive material, but when the matter comes before the court, the Secretary of State is obliged to claim PII. The PII certificate is then upheld by a judge, so the evidence about the essential basis for the decision becomes inadmissible. In other words, it's exactly the kind of case in respect of which Lord Kerr's questions, to which Lord Kerr's questions relate. Well, the answer given by Mr. Justice Ouseley is at 57 and 58 on MS 1630, and you can see what he says. That I turn to the possibilities. First, can the court fairly review the decision without a CMP? In my view, it cannot. Last sentence, it would be impossible for it to hold that her decision was irrational or unlawful when it could not know what she had considered. So my learned friend says, well, the conclusion of all this case law is that you simply assume that the magistrate got it wrong. Mr. Justice Ouseley is saying, applying al-Rawi, no, you assume the reverse. And why do you assume the reverse? Because there's a very well-established line of case law that says that there's a presumption of regularity in relation to official acts, a fortiori in relation to judicial acts.
I thought he was saying that you don't assume anything and the claim falls.
Yes, that's exactly right.
Well, that doesn't mean to say you assume everything's right. You're just
No, of course.
You're just refusing to adjudicate.
What he's saying is that he says it would be impossible for it to hold that her decision was irrational or unlawful when it could not know what she'd considered. Of course, I've accepted, I think, in answer to questions from Lord Kerr, that there are circumstances, including this case first time round, where a warrant might fall despite not knowing what information was before the magistrate, because you can see it on its face, or because it was improperly executed, or both.
But if you can't make a decision against the warrant, but there's no information to justify it, you were saying a moment ago, you assume all is all right. This decision seems to be doing something slightly different, although the result's the same, namely saying you decide you can't try it. It's a case on non-justiciability.
Well, it's not quite how he puts it.
It's a failure of proof, isn't it?
It's not quite how he puts it, because if one looks down to 58,
right,
second half of 58, if the Secretary of State gives evidence that there were good reasons and a sound relevant basis for her decision, having considered the claimant's representations, which she could not further disclose, it would be impossible for the court fairly or reasonably to hold that she was wrong in saying that. The claimant would have no prospect of persuading the court to the contrary. It is not so much that the case is untriable, it can be tried. It is simply that the evidence means that the claimant cannot win.
Yeah,
so there is
that's
no
the
point in
Rossminster
going
view.
to trial.
It was the next paragraph that confused me.
Yes.
The next paragraph, he says it's akin to the position in Carnduff, which I don't think it is.
It's not exactly akin to the position in Carnduff, but there are certain similarities. So your Lordship is absolutely right to say it's not quite Carnduff, because Carnduff is a case where the case is actually untriable. But there are certain similarities in that the presumption of regularity means that the claimant cannot win, and the claimant is the person who is seeking to challenge or impugn the warrant. Here.
You have to actually test it the other way around. In Conduff, if the government, or so if the police had been suing to try and recover payments which he had been paid and which the police were now saying had not been due, because he'd never done any work, for example, or he told lies or something, then presumably that would be untriable.
Yes.
In Conduff.
That's right.
Whereas in the present, I don't know whether there's an analogy in the present case, could the government ever be suing, but anyway,
yes.
There is a difference, as I think you accept.
There is a difference, but when you're dealing with an attack on a warrant, it amounts to the same thing.
Yes, I see that.
So that's the case of AHK. Now, we say, and I'm going to deal with it very quickly, that what my lords have been putting to me and my lady have been putting to me as the unpalatable consequence of this submission can be avoided if you reach the conclusion that the High Court can look at closed material. It can be avoided because it is possible to have judicial scrutiny of the reasons for granting the search warrant given by the magistrate if closed material can be considered by the High Court. Now, we accept the ratio of al-Rawi is that it's necessary to have a statutory authorisation for that to occur. So then the question is, where's that authorisation? And that is precisely the issue that concerned the court in Bank Mellat. So the court was concerned with the question, where in the statute, the Constitutional Reform Act, as it was in that case, do we see express words authorising us, the Supreme Court, to hold a closed material procedure? And the answer given by the majority was, well, there are no express words, but there are some very general words in section 40, subsection 5 of the Constitutional Reform Act, which say that the court's got to, has power to make whatever, or to make whatever decision is required for just disposal of the case, I paraphrase, but you have it before you. Now, we say that actually the parallel with Bank Mellat is a close one. And we make our points about Bank Mellat at paragraph 55 of our case. So I wonder, given the time, if I might try and make my submissions by reference to what we say there. So it's on MS page 114, paragraph 55. And we do say that the reasoning of the majority in Bank Mellat is applicable by analogy in the present case. The first point is that if you accept what we say is the proper construction of sections 8 and 15.3 of PACE, then this is a case in which Parliament has provided for a first instance procedure in which the court can consider sensitive evidence that has not been and cannot be disclosed to the subject of the warrant. That's the burden of my submissions on issue 1. If you're against me on that, then I'm not going to win on this point either. If you're with me on that, then one can then move to subparagraph 2, which is that, as in Bank Mellat, if that's right, it would be surprising, as Lord Kerr put to me, in those circumstances, if the court charged with reviewing the exercise of that discretion couldn't consider all the material that was properly before the decision maker when the decision was taken.
On this analysis, the divisional court should have looked at the material.
Well, could have. I mean, it decided that it wasn't necessary for it to do so. It said, what the divisional court said here was, look, there's been a PII process in front of District Judge Mellenby. It was repeated in front of His Honour Judge Bright. We don't need to redo that process. No one's saying that the PII process was problematic. We're dealing, the divisional court said, with a pure question of law, which was whether the Crown Court was entitled to look at closed material. So they took the view that they didn't need to, even though we, on our side, or Mr. Matthew on our side, was offering to the High Court that they could look at that material if they wished to do so. So, as I said, this part of issue 2 does not strictly arise on the Divisional Court's judgment, but we say, in principle, they could have looked at the material. And we do say it would be surprising, as it was in Bank Mellat, if the reviewing court can't look at what is before the court below. Third, we say, as in Bank Mellat, the alternatives are unpalatable. And I do commend the judgment in Bank Mellat, because Lord Neuberger goes through the alternatives. If we can't look at this material, then what? They're all unpalatable. Essentially, the most likely alternative is that, because of the presumption of regularity, see Rossminster, etc., all claims, almost all claims for judicial review, not all, but almost all claims for judicial review of a decision to grant the warrant will end up being dismissed. The other option, if you don't accept the Rossminster principle and you do accept the appellant's submission, is equally unpalatable. It's that the claim will end up succeeding, even though there was indeed material which properly satisfied the magistrate that the statutory conditions were met. The fourth point is, of course, is to answer my learned friend's submission that this is all very different because judicial review is a common law jurisdiction, not a statutory one. We say on that, of course, it's true that judicial review is a common law jurisdiction, but that difference should not be regarded as determinative, at least in a case such as the present, where what's being judicially reviewed is a judicial decision taken by an inferior court or tribunal pursuant to a clear statutory power. In that respect, we note and agree with what the appellant says at paragraph 28 of his case, which is that the availability of post hoc judicial review is integral to the system laid down by Parliament for search warrants. He says, of course, the consequence of that is that it feeds back to issue 1. We say, no, the consequence of it is actually that Parliament must have intended and envisaged that the power which it expressly provided was to be exercised pursuant to an ex parte application would be subject to effective supervision by the High Court. And the express statutory authority for a procedure in which sensitive material could be considered without disclosure at first instance must encompass also an authorisation for the High Court to consider such material on an application for judicial review if necessary for it to do so in order to do justice in the case. And finally, we note that the statutory origin of the appellate jurisdiction provides a weak basis for distinguishing Bank Mellat, given that the judicial review jurisdiction, even if not conferred by statute, is certainly regulated by statute. And we note in that connection section 31(5)(b) of the Senior Courts Act 1981, which entitles the court, specifically in an application for JR of the decision of an inferior court or tribunal, not in relation to other decisions, to substitute its own decision for the decision in question. And we ask the question, well, how is it going to do that if it can't see the material that was before?
We've given a judgment on this precise area last week, case of Michelak.
Ah, right. Well, your lordship has the advantage of me there, I'm afraid. I haven't been scrutinising your website carefully enough. My lords, my lady, can I move as quickly as I can to our submissions on section 59?
But I think my lord used the words that you used a moment ago. Section 31 of the Senior Courts Act didn't establish judicial review as a procedure, but rather regulated it.
Yeah.
But I was right. Avant la
I
lettre.
think we may have reached different conclusions
Yes.
as to the effect of that.
Yes.
But we better not get divert you into Michelak.
Well, I'm not going to get diverted into that because I haven't read it. So until I do, I think I better stay silent on it.
Well, if either side wishes to say anything, having read paragraphs 31 to 35 of my lord's judgment in Michelak, I think they better put it in writing after within a short period, 7 days at the most.
Well, Lord, can I deal as quickly as I can with section 59 of the 2001 Act. Section 59 is in Authorities Bundle 1, Tab 2, MS 526. It provides for two kinds of application. The first is an application under section 59.2 by a person with a relevant interest in the seized property. And the second is an application under section 59.5b by a person for the time being having possession in consequence of the seizure. Now, the purpose of providing for the second kind of application can be seen from paragraph 176 of the explanatory notes, which you have at MS 532. I'll just ask you to look at that because it's quite important when trying to understand what the purpose of the statutory purpose of this provision is. And if one looks at 176 halfway down, subsections 5b, 6 and 7 enable the police or other body in possession of the property to make an application to keep any material which they would otherwise be obliged to return if it would immediately become appropriate to issue a warrant enabling them to seize that material or to demand its production in the circumstances set out in subsection 7b. This means, for example, that the police will not have to return material which might be of value to them and then have to immediately obtain a warrant to seize it back. In other words, what this does is it plugs the temporal gap that would otherwise arise between an order in judicial review proceedings quashing a warrant or requiring the return of seized property and then an application to a magistrate for a second warrant. And the reason why that gap is a problem is that it allows for the destruction of potentially probative evidence. And that problem, or the fact that section 59 is designed to plug that gap and to avoid that problem, is set out in a number of cases, which I'm not going to take you to given the time, but I will ask you just to look at our case where we summarise them at paragraphs 16 to 18. And you can see there a number of cases. There's the case of El Kurd, there's the case of Panasar, the judgment of Mr. Justice Foskett, and in particular, one can see the reference to paragraph 18 from Panasar. If the materials had to be returned before a fresh warrant was issued, those suspected would then be in a position to destroy the materials before the fresh warrant could be executed. Parliament could never have intended to give that advantage to those suspected of crime. That's a divisional court of Lord Thomas and Mr. Justice Foskett. And then also there's the case of Chatwani. So you have all of those cases making clear what the purpose of this provision is. And one can then go on to say that if Mr. Summers were right that the judge hearing an application has no power to consider material not disclosed to the subject of the warrant, the result would be, of course, to confer precisely that advantage on those suspected of crime. And if you are impelled to reach that conclusion, well then, so be it. But whether you are impelled to do so depends, as it did in B Sky B and in Bank Mellat, on what you think is the proper construction of section 59. As to that, we say there are 3 points to make. First, unlike B Sky B, this is not a case where Parliament has expressly provided that the application should be made inter partes. It doesn't say anything one way or the other. It has been held that applications under section 59 ought generally to be made on notice, but there is an exception for cases of urgency. See Sir John Thomas, the president as he then was, in Van der Pale, Authorities Bundle 4, tab 40, MS 1680, at paragraph 98. We say that he was right to reach that view, and that the existence of such an exception shows that the requirement to make the application on notice is a matter of good practice rather than jurisdiction. The second point we made is the one that was put in argument by Lord Lloyd-Jones this morning, which is that when you look at section 59.7, it requires the judge to consider whether, if the property were returned, it would immediately become appropriate to issue, on the application of the person in possession, a warrant under which it would be lawful to seize the property. That inevitably means that the judge has to put him or herself into the shoes of the magistrates. And third, proceedings under section 59 have two of the features of the categories of case recognised in Al Rawi and subsequent authorities as exceptional to the general rule of full inter partes disclosure. The first feature is that, as in intellectual property proceedings, they are, where these kinds of procedures are adopted, they are interlocutory in nature. And that's a point that was again raised in argument this morning. They are ancillary to criminal proceedings. There's no question of deploying anything closed in the trial itself. And the second is that, as in parole board proceedings, which were the subject of the decision of the House of Lords in Roberts, they involve what was referred to there as a triangulation of interests, including in particular the interest in effective investigation and prosecution of crime. And for those reasons, we say there is every reason to
why is that triangle? Why are there three parties? I mean, who are the three parties? The state and the interests of crime are the same, aren't they? Interests of...
Well, Your Lordship might say that, but if one looks at Roberts, so that was a case where there are two parties in front of the parole board, and the triangulation of interests arose because there's also...
Public interest in third parties being safe.
Yes, indeed. Well, and that's the third interest here, the public interest in in the police actually finding the bomb.
In victims, as
yes,
those
indeed.
Whose crime or whose offences won't otherwise be prosecuted.
Indeed so. I mean, of course, on one level, of course, the police is representing those interests, yes. but they are different interests. Yes, people who, if you like, are going to be damaged by the suitcase of heroin that police can't get a search warrant to seize. For these reasons, we say there's every reason to uphold the Divisional Court's ruling that the procedure provided for by Rule 47.39 of the Criminal Procedure Rules is permitted by the statute. And I'll make the point very briefly, if I may, that if the suggestion is, and this is all, the argument has mostly proceeded by reference to common law authorities, but it's of interest to note that the Strasbourg Court, in the case of Share, very recently, only 2 years ago, looked in some detail at a warrant procedure where there was an ability for the court to look at closed material that was not made available to the subject of the warrant. Now, in that case, the warrant was not a search warrant, it was a warrant authorising further detention in the terrorism context. So, in fact, what was at issue there was an even more fundamental right than is at issue here.
You say they looked at it, I mean, looked at it without disapproval, or what?
Well, looked at it and found that it was compatible with Article 5.4, which was the procedural obligation applicable in cases where liberty is at play. So if one looks, for example, at, I'll just show, since your Lordship's asked the question, can I just show your Lordships and your Ladyship the judgment? It's Authorities Bundle number 5,
And 59.
Yes, it's tab 51 MS, sorry, so tab 59 MS 2202 is where it starts. And the key passage is at 2234. 153. This is what they say about the closed part of the hearing. It's true that part of the hearing on the 10th of April was closed to enable the district judge to scrutinise and ask questions about the Section 9 material. However, as the House of Lords explained in Ward, the procedure in Schedule 8 allowing the court to exclude the applicants and their lawyers was conceived in the interests of the detained person and not in the interests of the police. It enabled the court to conduct a penetrating examination of the grounds relied upon by the police to justify further detention in order to satisfy itself in the detained person's best interests that there were reasonable grounds for believing that further detention was necessary. The court is further satisfied that the district judge was best placed to ensure that no material was unnecessarily withheld from the applicants. So that is a procedure, a closed procedure on an inter partes application where the person who is being detained could make submissions, but not in relation to that part of the procedure where closed grounds were put forward to justify further detention. And it was a detention case where one would have thought the procedural rights, if any, were stronger rather than weaker.
On the previous page, 149,
Yes.
is the passage requiring disclosure of adequate information.
Well, there is, but that is subject, if one looks above, to this important caveat. Contracting, also in 149, middle of 149, contracting states cannot be asked to establish the reasonableness of the suspicion grounding the arrest of a suspected terrorist by disclosing the confidential sources of supporting information or even facts which would be susceptible of indicating such sources or their identity. So the requirement for disclosure of some information is subject to that caveat.
Yes.
It follows that Article 5.4 cannot require disclosure of such material or preclude the holding of a closed hearing to allow a court to consider confidential
No, but it's
information.
almost as if there is a but pursuant to 5.4.
Well, it depends which way you think the but is, but in the detention context, there is a requirement there for some disclosure, but not confidential sources. In this context, for the reasons we've given, I'm out of time on point 5, but I'll maybe give you a couple of sentences, if I may. We say there is every reason to say that there is no minimum disclosure requirement.
What was
that?
Sorry.
On that, you have our case very fully set out in the case. We say, in short, proceedings to challenge search warrants are not proceedings in which Article 6 imposes any irreducible minimum. I wonder if I could just ask you to look at, on these points, at our case, where we set out the reasons why we make those submissions at the end of our case, in paragraphs 75 to 77. The first one is that, of course, search warrants represent a significant interference with the rights of the subject, but then so do applications for warrants to interfere or to intercept private communications. And if one wants to try and find a spectrum, where on the spectrum do search warrants lie, that's a very good place to locate it on the spectrum. They are similar in terms of their intrusiveness and in terms of their interference with privacy rights, with interception of communications. And yet the Strasbourg Court has held in Kennedy that a completely closed procedure, much more closed procedure than this, if you like, in front of the Investigatory Powers Tribunal, We've explained in the case why we say it's a closed procedure, a more closed procedure than this, is compatible with both Article 6 and Article 8. The second point is that one shouldn't over-egg the extent of the interference, because the powers to seize material are strictly limited by statute, as they were by common law before. And the third point and final point, I promise I'll sit down, let Mr. Eady do the rest, is a third point that was raised in argument this morning, which is that judicial review challenges to warrants are dealing with the question whether the magistrate could properly reach the view that the magistrate did reach on the evidence before him or her. And that is inherently the kind of judicial consideration which is more likely to be suitable for resolution pursuant to a closed material procedure. See Tarrick, paragraph 147 in the speech of Lord Dyson, and K in the Secretary of State in the judgment of Mr. Justice Ouseley. My lords, my lady, unless I can assist further, I think I'd better hand over to Mr. Eady.
Just very quickly, in that case you referred to as Sher, there's also reference to the judge saying that there could have been a special advocate procedure. Do you know on what basis?
Well,
maybe
I think there was no, as I understand it, there was no express provision for it.
That's right.
But the position was that the judge could have, in the exercise of his inherent jurisdiction, invited the appointment of a special advocate, and we don't. Although there's, again, here, although there's no express provision for it, the judge could have invited the appointment of a special counsel if the judge had thought that necessary.
Yeah. Oh, there was a closed procedure, but no. Yeah, that's it. Thank you very much indeed. Yes. Mr. Matthew? Ms. Reedy.
Lady, very short, just one initial point. The court raised earlier this morning issues relating to the 2013 Justice and Security Act. And whether that was a subject in which the court was or should be interested. You will recall, I know you're all pretty familiar with the terms of it, but you will recall that there are at least two relevant preconditions to a CMP under that piece of legislation. The first of them is that the material in question is sensitive on national security grounds. No other. There may be overlap between serious crime and national security for obvious reasons. There may be overlap between national security and international relations for obvious reasons. But it's restricted under Section 6, sub 11, to national security grounds. And the second precondition for a CMP under that legislation is that it is not, quote, criminal cause or matter.
Yeah.
And I'm not going to get sucked into that debate. It's a live debate. And when I say live, I mean live in the sense that we had an argument about it last week in the Belhage litigation, where a decision by the DPP not to prosecute an individual is being subjected to judicial review. And the question is whether or not for that purpose and in that context, that judicial review amounts to a criminal cause or matter. So ultimately, in relation to criminal cause or matter, it's almost certainly a context-dependent question. You can have different meanings to criminal cause or matter depending upon which piece of legislation it sits in, and you'll be well familiar with the legislation governing appeal rights in criminal causes or matters, where you go past the Court of Appeal and come directly to this court. But the only reason for giving you that introduction is to urge caution before getting sucked into that territory. You don't need to in this case, because no one has asserted that the relevant sensitive material is national security sensitive material. So the first of the preconditions would not be met, meaning that you don't have to grapple with criminal cause or matter. I have almost no doubt that at some point the court will have to grapple with that issue in a context which is related to crime.
Yes, make those points clear. Right.
But that's the position in relation to the JSA. I hope that's helpful. The Secretary of State, as you know, intervenes because of the evident and serious concerns about the impact, if my learned friend Mr. Summers' arguments are accepted, on the prevention or investigation, prosecution of crime. If he is right, the impact on the search warranting regime and the consequential impacts on those public interests are obvious and severe. We want to make, if we may, 5 short points in relation to the issues that arise before this court. Firstly, Parliament has made express provision for applications for warrants to magistrates to be ex parte. And our submission is that, properly construed in context, that reference to ex parte proceedings permits and envisages 2 things. Firstly, that applications can be made without informing the person whose property might be searched. And secondly, that there can be reliance at that stage on information which is not disclosed to that person because of its sensitivity. The classic example being reliance on an informer whose identity must be protected. But my learned friend Mr. Chamberlain gave you a series of other bloody shirts and bags of heroin examples. And we respectfully submit that it covers the latter, interpreted properly in context, for obvious reasons. To name but a few, ex parte in this legislation sits in direct and stark contrast to the inter partes reference in the same legislation that was considered in B Sky B. And the analysis of Lord Toulson and the court in B Sky B is, we respectfully submit, telling because of that contrast. Secondly, because it covers the reliance on sensitive information as well. Secondly, because the consequences would be extremely serious if not. One is dealing with warrants sought at the early stages of investigation. One is dealing with a context in which one can posit for this purpose extremely serious crime. The examples my learned friend Mr. Chamberlain gave were indeed of crime of that nature. And if my learned friend Mr. Summers is right, even in that context, the position would be that a warrant might not be able to be obtained because it depended to a decisive extent on sensitive material. And it might be thought that in relation to the most serious crime, the category of most serious crime is perhaps the most likely to depend at the search warrant stage on informer information.
Methods of surveillance.
Exactly so. The state has devoted resources, developed sources and so on, in that most serious category. So it is not a fanciful conjecture. It will also not be lost on the court that if you take even that most serious crime, to some extent, on my learned friend's, or to a large extent, on my learned friend Mr. Summers' argument, whether or not you can or cannot get a warrant will depend upon adventitious circumstances, namely whether you do or you don't have to rely to a decisive extent on sensitive information. We also highlight as supporting that interpretation of the concept of ex parte in this legislation, but we also place considerable reliance, as the divisional court did, on the existence of the range of safeguards that are already built into this regime. The satisfaction of detailed statutory conditions, the mandatory requirements for the content of warrants, and most importantly, the need for an interposition of judicial examination. So for all of those reasons, we respectfully submit that that concept, which of course, as my Lord Hughes pointed out, doesn't necessarily connote the 2 things that I've identified. In context, we submit that that reference to ex parte does carry that import with it. Secondly, the second of the 5 propositions, there is a common law right to disclosure of the information relied upon in obtaining the warrant. But being a common law right, it is fashioned having regard both to the common law's astuteness to balance and protect all the various public interests that are in play, including in the protection of sensitive information and in the safeguards that the regime otherwise affords. But it also has regard to the legislative regime in which the right in question sits. It is, as you've seen from the cases to which Mr. Chamberlain took you, a right which applies after execution. It is, under all the case law to date, not an absolute right. All of the statements of the right have allowed for the non-disclosure of sensitive information. And that must be right. One couldn't sensibly have a situation in which it would be permissible to rely, for a policeman to rely before the magistrate in the initial ex parte application on information, but then have to disclose it the moment the common law right cut in. Or more accurately, because they never would disclose it, they would then have to withdraw the warrant the day after it had been obtained. That's the second proposition. Thirdly, the premise for what follows is that ex parte in Section 8 means what I've submitted under my first proposition it means. If there is statutory permission to make applications ex parte in that sense, which enables sensitive material to be relied upon, the subsequent procedural stages, do we respectfully submit, all necessarily fall within the logic of Bank Mellat. Bank Mellat, you've seen, Bundle 4, tab 45, page 1745. And the critical parts of Lord Neuberger's reasoning for the court are at 35 on page 1781-2, and so far as the less acceptable alternatives are concerned, 38 to 43 at pages 1782-3. But the key and fundamental point that he makes is that you would expect an appeal court to have access to all material available to and to the reasoning of the court below in order properly to fulfill its appellate function. So what drives that logic is the nature of the function that the court on top, if you will, is performing.
So what was the position then in Westminster, etc.? Did they just not see this?
There's no indication that they work this alternative through in those cases. As I understand my learned friend's submission, he spent quite a bit of time exploring that as an alternative, and the case law, with respect to him, seemed entirely to support the proposition he was relying upon it for. But the punchline of his submission, if I understood it correctly, was, well, there it is, that's the alternative, but
very unsatisfactory.
Very unsatisfactory, and therefore there is an alternative.
The answer is that
They didn't consider
they
this.
just missed it. They didn't think so.
I think in part because if you see from Westminster itself, it looks as though the revenue themselves were not mounting that as a possibility, and neither did the taxpayer in that case. But there's an
yes, well, maybe thank you. Yes, anyway.
But back to this, if that is the reasoning that works for appeals, and there, of course, you'll bear in mind that the relevant statutory wording that Lord Neuberger founded on was the entirely general wording about the Supreme Court operating justly. I paraphrase even more than my own friend Mr. Chamberlain, but they're entirely general words. If that applies to appeals, the challenge for my learned friend Mr. Summers is to state why, in relevant respects, judicial review of a magistrate's court by the High Court or Section 59 is, for present purposes, distinct. And my submission is that it is not distinct at all, but squarely within that logic. Focus for the moment on the High Court's ability judicially to review magistrates' courts. There is no ouster of the High Court's jurisdiction judicially to review decisions under Section 8. If you are to have judicial review, which plainly was in the contemplation of Parliament because of the absence of any such attempt at ousting, if you are to have judicial review, that function has got to be performed and capable of being performed properly. And for precisely the same reasons that Lord Neuberger relied upon, they can't do that in a judicial review of a magistrate's court decision without sight of the material and of the reasoning of, the full reasoning of, the court below. If you will, judicial review for the relevant purposes that we are considering is in truth appeal, but on rather more limited public law grounds. I don't want to complicate the analysis in that way, but you see the point. The logic drives one to the same place, unless you can produce a principled reason why it shouldn't. And so, as you see, that's the way that we put it. I confess, like my learned friend, I haven't yet had an opportunity to read the Michalak decision, but if and to the extent that it said that the Senior Courts Act established but didn't regulate judicial review, my Lord Kerr said it was the other way around. It was the other way around.
But it raised rather different questions
Yes.
about the difference between an appeal and judicial review, which is...
The short point I was going to raise anyway is that we don't need, I respectfully submit, the Senior Courts Act as the relevant legislation to get over the Al-Rawi problem in our case. The relevant legislative authority for the closed proceeding in the High Court on a JR is to be derived from the underlying statutory regime, plus, see Lord Neuberger in Bank Mellat, the court being able to perform properly its judicially reviewing function. So the core of the legislative authority here is not to be derived from the general setup of the High Court in the Senior Courts Act, but is to be derived from the ability of a non-ousted court to perform its judicial review function. That's how we put it. And then finally, in relation to...
Am I right, Mr. Eady, what the court was dealing in Bank Mellat with a statutory right of appeal?
It was.
All appeals to this court, well, nearly all appeals to this court
Are statutory.
That's why one was looking at the statute.
Exactly so. But I respectfully submit that the logic, the underlying logic...
Judicial review isn't dependent principally. There you will find something helpful in Michalak.
Yeah.
Isn't principally a statute-created function. It's a common law reviewing power.
Certainly. But of course one always has to have in the back of one's mind the Al-Rawi decision, and indeed to some extent Mr. Justice Ousley's decision post Al-Rawi about a JR in a naturalisation context. If we didn't have Section 8, if the underlying court which is being reviewed did not itself have permission to look at sensitive material in this way, then the argument would be much, much more difficult. And what that tends to illustrate is that it derives...
Yes, so this is, so to speak, an extension...
of the Section 8 permission.
Yes.
That's how we put it. And the alternatives, for all the reasons that my learned friend has gone through, are far less acceptable, including, if I may respectfully say so, the presumption of regularity, Rossminster et al. One can see the difficulties with simply presuming that the Crown wins. But neither of us, I think, is advocating that as our primary case. Mr. Chamberlain's analysis was simply, I think, designed to tee up that punchline, that there is a better alternative. And if that logic is right up to that point, then Section 59 can create no different an outcome given the jurisdiction in fact being exercised under that regime by the Crown Court than a JR in court. It can't give a different answer in that context, not least for the reasons, or in particular for the reasons which I think were the subject of Lord Lloyd Jones's question, that the divisional court founded on in paragraph 44 of their judgment, namely that the Crown Court is specifically and intends to put itself into the shoes of the first instance application for the warrant. And that feature creates an obvious statutory contrast with the position in, for example, B Sky B, where there was no underlying ex parte regime. If they're going to put themselves into the position of the first instance warrant question, then they do just that, and they do it with the ability to receive the same material. It's also to be noted in relation to B-Sky B that we're not here dealing with a specialist journalist regime. We're not dealing with a deliberate choice by contrast in relation to the application, and thus at the base of the regime the question was and is different. Here we're dealing with ex parte sitting at base, and for that reason we respectfully submit the approach must be the same. That's the third proposition. The fourth is that there is no al-Rawi problem here. The base of the reasoning of the Supreme Court in al-Rawi was that CMPs were simply too controversial to be invented by the common law, and statutory authority was needed. However, it is evident from al-Rawi itself and from Bank Mellat, which followed, that one can have statutory authority derived from either general words or by way of implication into a statutory regime, if that is what is required, having regard to the essential functions that the court is performing. In regard to Bank Mel as an appellate function, and we say in relation to the High Court an essentially equivalent function of JR. So that solves the al-Rawi problem. That leaves the question of whether there is an irreducible minimum, either at common law or under the ECHR. At common law, the short answer is that absent ECHR, the court wouldn't impose such an irreducible minimum for the simple reason that it would cut across the legislative regime. And under the ECHR, we respectfully submit that there is no irreducible minimum for all the variety of reasons that my learned friend Mr. Chamberlain set out in his case and we've set out in ours. By way of 10-second summary, liberty is not at stake, contrast share. There are thoroughly important public interests and protective consequences if the appellant is right, and those are important and relevant to be taken into account. We are here dealing with the pre-trial stage, an early stage of a criminal investigation, and of course there are additional protections further down the line, including Section 78 of PACE. And finally, and perhaps most importantly, or certainly a relevant and important factor, on a JR from the Magistrates' Court, one is dealing with the question of lawfulness. And the significance of that is that it stands in sharp contrast, i.e. the function that the court is performing on a judicial review, or indeed on a Section 59 application, that stands in stark contrast to the sort of situations that have been considered as precluding, as it were, or as leading to an irreducible minimum, control order, asset freeze and so on, where there will be, or there is likely to be, a pressing need for the person who is subject to the state measure to produce their tale. And if one thinks about it in the context of a search warrant, one is really not in that territory at all. Think about the statutory preconditions. This isn't a question of them offering a tale and producing a set of facts which might cast very different light upon matters that the court relevantly has to consider. So we're here dealing with lawfulness and the lawfulness of a decision by a lower court applying the statutory preconditions that you've seen in the legislation. So for all of those reasons, we respectfully submit no irreducible minimum.
Let me get it straight. What we're dealing with is JR of the Section 59 decision here.
We're dealing with JR, in principle, you're dealing with Magistrates' Court decision, JR of a Magistrates' Court decision straight, and then...
That's been conceded, has it, though? I mean, because that was, the warrant was set aside, but is it still alive?
Well, I think that issue is, because it's as it were, part of the critical path of analysis.
Right, it's a number one issue.
I think it is. So you're dealing with Magistrates' Court, JR from a Magistrates' Court,
yes.
Then you're dealing, as it were, in parallel, because of the strangenesses of what happened below, with Section 59, what can the Crown Court judge do, and necessarily from that, JR from that.
Yes. And you can batten on the limited, well, whatever is the nature of the review on Section 59, you should say that should be mirrored upwards. And here, in relation to an appeal which comes from a JR of an original decision, you haven't quite got the same argument, but you say as a matter of common sense there must be.
It must be the same. I mean, I suppose one has to logically take it up to this court.
Yes.
You'd end up it would be Section 8, magistrates, JR to the High Court with whatever Mishlak said about all of that, but we respectfully submit founding back onto the base regime and the essential function of the court, then appeal up to this court, which is, as it were, much more directly Lord Newburger and Bank Mellat. Yes. But that's how we respectfully submit the analysis works, and all of it, as you will have detected, we respectfully submit, flows from that base statutory authority to do the ex parte thing, whatever that means.
Yes.
My lords, my lady, those are my submissions.
Thank you very much indeed.
Much obviously depends in Chapter 1, as I've termed it, the issue of jurisdiction, which end of the telescope you look through. Do you start with the magistrates' court and then try and extrapolate upwards from that, or do you start with the judicial review and seek your answers there? Starting with the magistrates' court leads immediately into the difficulty, as my Lord Hughes points out, that the ex parte nature of the process in fact says of itself nothing about whether the court there can look at undisclosable evidence or not. The only correct way to deal with this case is to start with the powers of judicial review and extrapolate either upwards or downwards, depending on which way you need to go. Can I deal with a number of sub-issues on what I've termed Chapter 1, the issue of jurisdiction? Firstly, the criminal procedure rules, and 5.7 in particular, whether it is, as I have termed it, a PII regime, or whether it is, as Mr. Chamberlain terms it, an authority for withholding evidence, which will, if right, end up depriving the subject of the warrant from access to any evidence upon which to bring a meaningful judicial review. I'm prepared to accept, for the purposes of argument, that Mr. Chamberlain is right about that. And 5.7 does in fact...
5.7 6.
5.7 Rule 6
yes.
Talks about withholding evidence, or could be construed as withholding evidence. The essential point to make here, though, of course, is 5.7 covers a gamut of potential warrants, which will include some to which statutory closed process does apply. For example, warrants for further detention under the Terrorism and Counter-Terrorism Act.
Well, it's not just warrants anyway, is it? This is fairly early on in the criminal procedure rules. It's about everything. Court records generally.
Absolutely. And so it will include...
For example, it would include the transcript of the PII hearing.
It would, but it would also include statutory CMPs, and for that reason doesn't take us any further forward. Secondly, is this case properly to be brought within B-Sky-B, paragraph 28, that category of cases where there is in fact no list between the parties? What this court was talking about there, in our respectful submission, is applications to third parties in circumstances where the application did not trench upon that third party's property rights in any way. So a witness summons, for example, there's nothing that would...
But does that create, firstly, in one of the cases, if I'm right, it was an application to a third party as far as your personal client is concerned. Wasn't it an application in respect of company premises, yeah?
Yes.
So that on your case would be within paragraph 28, whereas, and even if it's such warrant in respect of an individual's premises, how do you know that the documents are relevant to him? They may or may not be.
Well, I have a note at the bottom of this page that says Lord Nant's Section 8 application against the third party. I have to say it's something I've never come across before, but when one looks at Section 8, one can conceive that it could be utilised in that way. It's not in practice, it's not our facts, but if it were to be utilised in that way, and if the company premises were to be deemed third party.
I wonder if you're right. I mean, I would have thought it was not uncommon. We've got have we got specific provisions like the journalists and accountants? But that's the sort of situation in which you could well go after documents or material in some
But that's
third-party
usually
offices.
the function of a production order.
I see.
But let's assume.
Forgive me, Section 8 isn't about a suspect. It's about the suspected presence of property.
Absolutely. Well, that's not how it's often used in practice. But let's. I'm not going to take issue with the court at this stage. You are still then targeting your application against a property holder. You're not talking about a witness and compelling a witness to come. You are still interfering with property rights of the property holder in those circumstances. And so in those circumstances, you would be dealing with a lis as between the police and the property holder. You would be infringing the property holder's rights. The fact that B was concerned with a statutory process for inter partes proceedings doesn't take us any further. The key to B, of course, was the existence of the lis. Here there is one undoubtedly, police against suspect. There it was the journalist with his property rights. But if there is significance in the fact that B was concerned with statutory inter partes procedure, then that significance must flow in our case into the Section 59 procedure. It's a statutory inter partes procedure, and by implication into the judicial review procedure, which is also inter partes at common law. Thirdly, the cases that Mr. Chamberlain relies upon that concern PII, they are of course a subset of cases that are concerned with the common law right to evidence in a judicial review, which is of course a direct product of the common law principle of natural justice. But insofar as that subset of cases are concerned, none purport to be dealing with the situation of withholding evidence as opposed to PII. The closest...
This subset of cases is...
Cronin, energy finance, banks, all of those small number of cases where the court talks about withholding information in the provision of, talks about the right to provision of the information and talks about withholding parts of it pursuant to PII, but does so in relatively loose terms that could be construed as withholding evidence. The closest we come to, by and large, those cases don't talk about the kind of information that they are concerned with. The closest we come to is Cronin when it talks about the identity of the informant. Can I deal with, therefore, the issue of informants? And the issue of reliability or identity of informants and whether it's something that is going to go to the jurisdiction to grant a warrant. Our case is it's certainly the case that it's necessary for the judge to grapple with and examine the reliability or the identity of the informant, certainly the reliability of the information or the informant, and in certain cases that may include the identity of the informant where it bears on the reliability of the information. The reason the judge needs to do that is because of the reasonableness of the grounds of belief. Is that PII material that can then be withheld? Let's assume it's not. Let's assume it's evidence. There is case law that deals with this. Austin, tab 34, paragraphs 33 to 47, bear reading. They contemplate that there is some limited review of the issue of reliability of information at judicial review level. So let's assume that we're talking about evidence when we're talking about the identity or the reliability of the informant as opposed to PII materials. What are the consequences of that? The consequences, if I'm right about Chapter 1 and there's no closed material process authorised, is no warrant. Of course, only in situations where there can't be disclosure of the reliability or the identity of the source, because the source is the sole basis of the evidence and their reliability or identity is entwined with the information they give. Those cases, on any view, will be rare, but they are the price we need to pay for natural justice. I'll return to those same facts, if I may, when I reach Chapter 2. But confronting, as I must, the difficult case in which there is an informant, it's the only source of information, and their reliability, their identity cannot be unentwined from their information. Our case is bluntly that there can be no warrant, and that is the price we pay for natural justice. Can I therefore come back, please, to Chapter 1 and deal with Rossminster and the idea that we should just assume that the Crown wins? My learned friend presents Rossminster and that bunch of cases as concerned with what happens when the High Court cannot look at closed evidence. I don't agree with that at all. They are not concerned with what happens when the High Court cannot look at closed evidence. The High Court is looking at and having regard to closed evidence in those cases. The presumption of reliability rests on an evidential showing from the Secretary of State or the police that the evidence was before the court below and it was sufficient for those purposes. That the court is taking into account and assuming that there was such evidence before the court below. That is flatly inconsistent with Al-Rawi. It's closed process by the back door. It allows the state to assert without evidence that there was sufficient evidence below, and it's the state's evidential assertion that is the closed evidence.
So it's not that the High Court is looking at the material, but it is assuming that it has been looked at below.
It's looking at an evidential assertion that there was
Yes.
material below.
Yeah.
And it's having regard to that evidence without looking at it. And that's precisely what happened in AHK, paragraph 58. Mr. Justice Ousley permits the Secretary of State to assert in evidence that there was an evidential foundation for its underlying decision, and then extrapolates from that. That is closed evidence. And it does denude judicial review of all content in this area, as the House of Lords expressly acknowledged. Can I deal with three other sub-issues on what I've called Chapter 1, this idea of triangulation of interests, the idea that informants, or the interests of the informant, and the public are somehow separable, and the support that's derived for that from Roberts. Roberts did indeed suggest that this was the case, but not for the purpose of carving out another exception to closed evidence. Of course, the ultimate result in Roberts was that there was statutory authority for the closed evidence in this case, not that there was a triangulation of interests that could justify some new exception. It wasn't suggested anywhere, including in Al-Wari, that crime is some general exception to closed process. And in any event, for the reasons my Lord Mance gave in B against Westminster, this isn't triangulation in the sense that we are properly concerned with. My learned friend dealt with share. So far as the warrants in that case, the search warrants in that case were concerned, there simply weren't any arguments about the process there, no doubt because sufficient information had been given to the detainees during the process of their detention. So far as detention was concerned, that was based on a statutory process, and paragraph 149, as my Lady Black observed, says in terms, or repeats in terms, the A against UK minimum disclosure requirement. The end four sentences of that paragraph, paragraph 149, are plainly a caveat to the general statement that precedes it. The idea that the general statement that precedes it is a caveat to that, and that one should read it backwards, is with respect.
Sorry, what page was that? I remember.
This is Share, tab 59, paragraph 149. May I
Yes.
find?
No, I remember it.
It's coming. Yeah. Whilst it's coming, can I deal with another issue? Sorry?
It's 2233.
Thank you.
Thank you.
Can I deal with another issue? My Lord Mance raised it at the beginning. Mr. Chamberlain didn't press it, but it then appeared later on. The idea that Section 78 in the criminal process may hold some clue to all of this. The reality is Section 78 and the remedies available in the criminal process are of no value whatsoever. Firstly, because it's no part of the function of the trial court to be concerned with the legality of the warrant. That is the only court with competence to concern itself with that issue is a judicial review court. And secondly, because it's circular.
I mean, great respect, Mr. Summers, that's simply not right. The court might be concerned with the validity of a warrant, but what it would principally be concerned with would be the fairness of proceedings resulting from the execution of the warrant.
My Lord's absolutely right.
Sang and so on.
It's not concerned with the legality of the warrant, it's concerned with the legality of the process and whether that should lead to inadmissible evidence. My second point was that it's illusory in circumstances where the defendant will not have had access to the judicial review, won't have any judgment to rely upon, or evidence to rely upon.
Might not even be the householder concerned.
Well, quite. It simply it shouldn't be assumed that a defendant, if he is the subject of the criminal investigation, will be in any position to exclude the evidence based on the illegality of a warrant in circumstances where he hasn't been able to litigate the illegality of the warrant with any real effect. Bank Mellat, both, as I understand it, my learned friends accept ultimately that none of these peripheral points get them home unless they have purchase in their Bank Mellat argument. The idea that Bank Mellat simply missed. Let me start again. There are two things to say in brief about the Bank Mellat argument as advanced. Firstly, Rossminster. It didn't miss this whole issue. What it did was recognise, and this is Lord Diplock, page 1013F, MS, page 680, that the High Court, acting as a reviewing court, is not a court of appeal. There's no dissonance between the fact that Rossminster didn't afford the High Court closed process and Bank Mellat. The reason that it was not taken up in Rossminster is because it was accepted there that the judicial review is not the same thing as an appellate jurisdiction. That's precisely the same thing as we understand it that this court held last week in Michelak. Judicial review cannot partake of the nature of an appeal. The court simply cannot substitute its own decision. The principled reason why judicial review doesn't have the character of an appeal for Bank Mellat purposes is the nature of its jurisdiction. Whatever the position of a statutory appeal, where Parliament can overrule the requirements of the common law natural justice, simply don't apply to a jurisdiction founded in the common law. And that's precisely what this court held in Al-Rawi. Hence it is that Al-Rawi, both majority and minority judgments, all make clear that its ratio applies directly to judicial review. The issue of appeals obviously wasn't precluded from further litigation by Al-Rawi. The issue of judicial review in our submission plainly is.
Okay, can't judicial review take its shape from the nature of the subject matter to which it's directed? I mean, you say that a common law scheme is immune to the sort of infection upwards that a statutory appellate scheme may be subject to under Bank Mellet. But I'm just asking, why is judicial review, can't it take its flavour to some extent from the nature of the issue?
I don't dispute at all that a judicial review can have different features and characteristics depending on its context and subject matter. But in the criminal context, it is anchored in the common law power, and that common law power must be subject to the common law rules of natural justice. Can I therefore, all of those considerations, we say, compel a positive answer to Chapter 1. Chapter 2, irreducible minimum disclosure, can I say no more than two things about? Firstly, the idea that this case is somehow comparable to or benefits from analysis with Kennedy, tab 28, on the basis that it was a state application for an interception warrant is, with respect, simply misconceived. The opposite is true. Kennedy concerned a speculative claimant applying without proof of state interference for an order under the Human Rights Act. That is abundantly apparent from paragraph 190 at page 1327 of the European Court's decision, and informed their decision to a definitive extent. This case is a state application for interference with fundamental rights. Kennedy wasn't. So far as Chapter 2 is concerned, can I come back to our unreliable informant position and the idea that the warrant had not to be granted in that case? If the court's against me on Chapter 1 and jurisdiction and is considering Chapter 2 on the basis that there is a closed procedure in play and Parliament has provided for it, those same facts would be capable of being dealt with under Chapter 2, that is to say, minimum disclosure. Under Chapter 2, what would be required would be a gist of the intelligence. It would no doubt say that the intelligence has been assessed to be reliable. It need say no more. Gisting for the purposes of irreducible minimum disclosure under Article 6 simply does not require either the source or the source's evidence to be disclosed. Paragraph 66 in AF number 3, Lord Phillips makes clear that what is required by Article 6 irreducible minimum disclosure is a very different thing from what is required in the general criminal context. Davis would be identity of the informant. That is not what is required by gisting in this context. And so with that...
What does it require? It requires just...
the information, the allegation, the essence of the allegation. And here it would be, this is our information. It's from a source that's assessed to be reliable.
And that was paragraph 66.
66 makes clear that this is not the same thing as Davis' identity of the informant. And that emerges, of course, from A against UK, paragraph 220. The way it ought to work assuming that there is power for special advocate at this stage, because we're talking about a closed material process, the defendant, armed with the allegation and the assertion that it's assessed to be reliable, ought to be able to tell his special advocate, well, if this comes from my vengeful ex-girlfriend, you, special advocate, can have this information to go into closed session and to test that assertion. So the defendant is protected and does have the ability to test the information in some respect. That is how the system ought to work. If the reality, however, is even that kind of gist cannot be given on the facts, we're in the realms of Chapter 3, and the presumption of regularity, again, in addition to all the other problems with it, insofar as it results, because it just assumes the Crown wins, insofar as it results in state action being upheld without disclosure of evidence, it is one, inconsistent with the usual application of judicial review in the human rights context, where the onus is and ought to be on the state to justify its interference. And secondly, inconsistent with the avalanche of cases concerning non-application of Carnduff in the modern criminal context, as opposed to the context that appears in Al-Rawi or AHK. My lords, I see the time. I've trespassed already by 2 minutes. I'm going to say no more, unless I can assist further.
Thank you very much. Yes, the court is grateful for the submissions by counsel and will take time to consider it. The court's adjourned.